Okay, I think everybody's muted. Let me full screen here. We'll get our little slideshow going. The slides are mostly to remind me what's going on. And so we'll go. A couple more people have come on. Thank you. We just had our boot camp in Salt Lake City on Monday and Tuesday. We take our dozen people and spend 2 days with you, and it's actually kind of fun. I enjoy it. We eat breakfast and lunch together, and then in the evening we do one-on-ones with everybody, so they get to basically boil down what they're doing as compared to what we've talked about during the day. So it works out to be fun, and I think everybody is happy when all's said and done. At any rate, we've got a few questions, not as many today, so we may be a little shorter. And if you have questions, you can type them in. Soraya will remind me that they're there. What I ought to do is do the little plussy on the questions so I could see anything that's coming up. At any rate, let's get going and not waste your time. Thank you for attending. The question came in, how do I buy properties in a trust? And right now I'm buying all my properties in LLCs and stuff. So what do I do? As is always the case, when the questions are typed and they're one sentence, I don't fully understand the questions because your question always elicits another question from me. But let me answer best I can, okay? You can buy properties in a trust, there's no question. I assume this is real estate investing. Lots of people buy properties in a land trust. A land trust, in my opinion, is just a baby living revocable trust without a lot of the provisions. They're always revocable. There could be an irrevocable land trust, but they're pretty much always revocable, which means that they don't give you any asset protection. And so the argument is, well, should I buy the property in the land trust for the anonymity? And my answer is, doesn't hurt, but it doesn't help much. We can pretty much trace you down with no problem. I don't care which way you come at it at. For example, if there's a mortgage, I got you. I mean, I can get every mortgage on you in 15 seconds flat. If you've put your name on the tax rolls, if your name's on the property as the trustee, which somebody's got to be on as the trustee because technically the trustee owns the property. I'm going to talk about how to actually buy properties in a trust and in an LLC, the procedure here in 2 seconds. If you buy the properties in the LLC, and they said they're buying their properties in LLCs now, that's wonderful. I like that. I want to caution you, though. You can't get too many of these LLCs up in the air all at the same time because they have to have paperwork associated with them. You have to do, in most states, a state filing every year. You have to do a tax return every year. You have to do this. You have to, and you should follow all the formalities, the business meetings. You should keep separate books and accounting. Don't commingle money. Follow all of the rules associated with the corporate shield or the corporate formalities. Now, some people say, oh, you don't need to do all of those formalities for an LLC. Actually, that's true. In many states, Utah, for example, state code says don't have to follow formalities, can't pierce the corporate veil. But in reality, when you get into court, the argument is this a real company? If not, it's your alter ego. We pierce the corporate veil. We come after you personally. So the way you prove that it's not your alter ego is you say, okay, Your Honor, I did all of the formalities. I held my meetings. I didn't commingle money, blah, 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 blah. And so there is a fair amount of work associated with each one of these LLCs. You need operating agreements. Yeah, they may all be the same operating agreement, or at least knockoffs, but you need separate paperwork. I mean, you just can't, it'll bury you. So do you have a separate LLC for each piece of property? Good idea. Practically speaking, though, it may not work for you. And you've probably heard the story about the two doctors in Long Beach that had 53 properties, and the lawyer put them into a separate limited partnership. That was before the LLCs came around, and this guy's still out preaching limited partnerships. I think you should use an LLC over a limited partnership because there's nothing you can do with a limited partnership that you can't do with an LLC, and the LLC has the corporate shield and no general partner like limited partnership has. So, limited partners not liable, general partner liable. Remember that? LLCs don't have those. Anyway, these two docs, they've got 53 properties. The lawyer sets them up with 53 LLCs, and he only charges them $5,000 per LLC. And then he says, oh, you really don't want these in California because the California state fee every year is $800. You want them in Utah. It's only $20 or $12 or 15. I think it's $15. And so you should put them in Utah. And it's going to be in a foreign state. You need a registered agent. I'll act as the registered agent. I'm in Utah. And I'm also an accountant. I'm not just an attorney. I tell you what, I'll act as the registered agent. I'll do all the taxes for each one of the limited partnerships. And you two doctors, you just go chop up people and have a good time. I'll take care of everything. I'll issue the K1 to you. And I'm only going to charge you $1,500 per 53 limited partnerships. In the end, the two doctors call me up and they say, Lee, we're not worried about asset protection anymore. Our lawyer has all of our money. How do we get out of this? So don't go overboard. Procedures to buy properties in a trust. What you're going to do is at the closing or before the closing, you're going to say, hey, Mr. Title Company or lawyer or whoever's doing the closing, I want this property to be held in the name of my trust. Now, they're not going to ask you what type of a trust it is or anything else. They don't care. You're going to technically take title, or at least you're going to get the mortgage in your own name, not in the trust's name. Mortgage companies can't tell what type of a trust you have. They're too stupid. If they read them, they could tell, but they're not smart enough to read them, and there are trusts that could screw the mortgage company. So the mortgage company says, no, we're not lending any money on a property that's owned by a trust. So you're going to get the property, and you may actually have to take it in your own name and then move it into the trust, or very often you just sign all of the documents for the mortgage in your own name, and then at closing, you say, put it in the trust. The trust has three parts to its name. It has the name of the trust. In the old days, that used to be the Lee Phillips Living Revocable Trust. Today, we make up a name for the trust. I'll pervert your first name and last name, the Leaps Trust or some such thing. Or you can name it anything you want. Some people pick their favorite Hawaiian word. Some people just say the Green Plant Trust. Or people in the land trust business put the address of the property, which is kind of stupid because you're doing anonymity. Remember that? A guy called in a few years ago, and he said, I can't do this, I can't do this. We were recommending all this stuff, and he says, no, I'm anonymous. I'm off the grid. Can't do any of this stuff. Finally, we threw up our hands and we said, okay, give us an address. Give me an address of a property. I don't care if it's owned by the land trust. I don't care who owns it. Give me the address of a property. Now, doesn't your tenant know the address of the property they're living in? We did a printout, and I'll give it to you. It cost us some money, $70-ish type thing. But we came back in about 20 minutes. We had every relationship this guy had ever been in, business, personal. We had every checking account he'd ever opened. We had every mortgage he'd ever had. We had every trust he'd ever filed. We had everything in the book on this guy. We printed it out, faxed it to him, and he called us up in about an hour, and he says, okay, anonymity doesn't work. What do we do now? The trust you're going to use is the Living Revocable Trust. and you're going to put your property, your house in it, and it's going to avoid probate when you die. That's basically all it's going to do, and then it divides the property up and basically tells how people are going to inherit the property. But it is not an asset protection tool. It is a probate avoidance tool. And the land trusts in many cases do not have provisions which talk about what happens to the property after the guy dies, and so you end up with a trust that doesn't have a probate avoidance. Well, it technically has a probate avoidance, but we don't know what to do with a piece of property after the guy dies. So trusts, great, buy them property directly in the name of the trust. You're always going to buy your personal residence directly in the name of the trust. If you're in Florida or Texas, where we have the full homestead laws, then you need to make sure that your trust is going to keep the homestead in place. And there's a provision that you put in the trust document which talks about the homesteads. How do I buy property in the name of an LLC? Oh, let me go back, can I? I said that the trust had three parts to its name, the name of the trust, and we got on that. Also, the trustee has to be listed. You have to have the name of the trust, the date of the trust, because you can create more than one trust, and then the trustee has to be listed. Technically, the property is held by the trustee. The trustee is the owner of the property. Now, they're the owner of the property under their fiduciary duty, but the trustee is listed. If you are listed as the trustee, your name's going to go on the computer files, and they're going to be able to see immediately that you have the piece of property. Like I said, we can usually figure out 99.9% of the time, we can figure out which pieces of property you've got in your trusts and your LLCs and everything else anyway. So it doesn't upset me. Name of trust, date of trust, trustee. If you don't have all three, you don't have good title. Buying property in the LLC. There again, you're going to get to closing and you're going to say, I would like to put this in an LLC. Many times the mortgage company is going to object. They cannot object to you putting the piece of property into the living revocable trust because that is just you. Doesn't matter if you call it a living revocable trust, a family planning trust, a land trust, whatever it is. If it's you, you are the owner, you are the grantor, you are the trustee, and you are the beneficiary. It is you. They can't say anything about it. Now, I might put a little asterisk here. If you're not the grantor, the trustee, and the beneficiary, technically you have just violated the due on sale clause under the Garn-St. Germain Act. So, let's think about it before we start playing the game with who's trustee and who's beneficiaries. Anyway, when you go to put the property into the LLC, you will put the name of the LLC on the deed, and then you will sign the deed, but you want to make sure that you put your name with the designation manager after your name. You are not signing on your behalf, you are signing on the company's behalf. And you can certainly put the property into an LLC. When you do that, it now is a commercial property. It is not an individual investor property. It is not a personal residence. And the property taxes will almost triple. And the insurance will almost triple. If you don't tell the insurance company that it's in an LLC, then you're not insured when the place burns down. Many times, however, and I've done it on my pieces of real estate that I own, the LLC, if I explain everything to the insurance agent will go to bat for me, and in about 80% of the cases, the insurance company will say, yes, we will list the LLC as an additional insured. That way, I know that they know that it's owned by the LLC, and they have not increase the rates. Now, I've had a couple of pieces of property that have said, no, we're doing this. You put it in the LLC, we're going to triple your rate. So, buy the piece of property in the LLC. It's easy. You just put the LLC's name on the deed, and you sign as manager, not as you as an individual. One more point, if you are moving property to an LLC, it's in your name now. You want to put it into your LLC, that's fine. However, two things. One, if I'm giving property to my LLC, aren't I? If you were giving property to my LLC, what would you want to see in return? You would want to receive a membership interest stock in the LLC to show that you owned a piece of it, right? Or you would want a note back, because you're not going to just give your piece of property to my LLC. Well, if this is really an LLC and not just your alter ego, when you put the piece of property in, hadn't you better get something back? When you give IBM $100 in stock, or excuse me, $100, they give you $100 in stock back, right? When you put your LLC in, I want to see something come back, or when you put your property in the LLC, I want to see something come back. Membership interests, a note, something to say that this was a real transfer between two independent parties. If you just put it in willy-nilly, I'm going to get you in court, and my argument is, Judge, these guys don't care. This isn't a real company. They knew that. They put the piece of property in. They didn't get anything back. They didn't get any ownership. They got nothing. I mean, if it wasn't really their alter ego, would they just be putting in a piece of property and not getting anything back? I don't think so. So that's an excellent way to pierce the corporate veil on the LLCs. So putting property in. The other thing is you should use a warranty deed, because if I'm moving property from me to my living revocable trust, that's still me, isn't it? So the title insurance, all of the stuff, all of the warranties that come with the title that I paid for, or that were already on title, they all continue on if it's me. But if I'm moving the property from me to my LLC, if I don't use a warranty deed and continue those warranties, they're lost. So always use the warranty deed. Okay, a couple of points on taking property in an LLC. Question came up, do I have any prototype self-directed IRA documents? And the answer is no. Self-directed IRA documents are unique to the self-directed IRA trustee, the guy who's setting it up. Now, he has to follow the IRS code and all of that sort of stuff. And the question was actually, do I have self-directed IRA documents approved by the IRS? Every one of them will be approved by the IRS, but they can put other little things in there. And that relates to the management of the self-directed IRA by the self-directed IRA trustee. So they can put their own BIPIs in, and whenever you go to a self-directed IRA guy, he's going to require that you use his documents. So there's no use my having a set of, quote, prototype IRA documents. There are other plans, and the question continued on, how does a small business save taxes? Well, it can be your small business. You can have 1 or 2 employees. You can be doing the real estate and an S-Corp. You can be doing all sorts of stuff. Fund the retirement plans out of your company. The 401k, the Roth 401k, the SEP, the Simplified Employee Pension. Those are all things that a little company can do. Now, I do have all of those prototype documents in the Flexible Benefit Plan Retirement Savings Plan set. And that has just been updated, totally redone in the last couple of months. The SEP is kind of neat. I use it. What you do is you adopt the documents, you sign the documents, and then you go down to your favorite IRA trustee. That could be one of these self-directed IRA guys, or it can be your favorite bank. And you set up an IRA. It's just a regular IRA, basically. They'll have you use a little different form, but it's a SEP IRA. You set it up with the guys, you sign the papers, and then the company, the employer, has to make the contributions. An employee cannot make a contribution to a SEP. But I can put up to 25% of the guy's salary in, or $53,000 in 2016. That's not bad. Company gets a full tax deduction for it. It does go in after tax to the employee. But I now have $53,000 in an IRA, basically. Excuse me, it's after tax. Well, it goes in tax deductible to the individual and tax deductible to the company. I screwed that statement. If you want to convert it to a Roth, you're going to have to pay tax. Okay, but you can put a fair chunk away tax deductibly to the company and the employee. The catch is the employer has to make the contribution. But if it's my little company, I'm happy to make the contribution. And that, by the way, all comes off above the line. You might remember it actually lowers the owner's adjusted gross income, because the money from the company is not included in the calculation of the adjusted gross income. So use the 401ks. What are we, about 16,000 this year on those, something like that? And if you really want to have a little more money put away, use the SEP. And those documents are in the Flexible Benefit Plan Retirement Savings Plan set. And of course, there's a recorded explanation on each one of them. Trust distributions, multiple lump sums. The question comes in, I want to make multiple, I want to divide the property equally between my kids, and I want them to have some now and some later, 2 lump sum distributions, and I don't want them to know about it. I'm not quite sure what the secrecy is, but normally, and it's not unusual for us to set up a trust so that the distribution pattern goes something like this. When the youngest child reaches age 30. Now, we do it when the youngest child reaches age 30 instead of the oldest child, because I don't want to penalize the younger children. If I've got one kid that's 30 and then I've got a caboose that's only 15, and I make the distribution when I die, the oldest kid's 30, then the oldest kid gets his piece, the 15-year-old gets his piece, but the 15-year-old's going to have to live on his piece. The 30-year-old, I paid for his college, I paid for his wedding, I did all of this stuff to get him up to 30 years old. The 15-year-old, no, he's going to have to take his money to do all of that. If I keep it all in one pot, and I can direct the trustee to use the property to help all of the kids, the 30-year-old could get help with a down payment on his house. The 15-year-old, I could pay for, the trustee could pay for his college education, his wedding, and all the stuff that I did for my older son or daughter. So we hold it until the younger kid gets to be of a certain age. Then it is not unusual to say, okay, divide the trust into 4 equal shares. Each kid gets an equal share. And we usually make it so that if one of the children has died and has left their own kids, grandkids, then that child's portion, the child who died, their portion would go to their children. If the child has died without leaving heirs, then it would just be divided one less way. There would be one less equal share. So anyway, we divide it into 4 equal shares, and then we give each child their 1/3 of their share. And then 5 years later, we give them another 1/3 of their share. And 5 years later, we give them the rest of the share. So you can do stuff like that. We can set it up so that we divide it when the youngest gets to be 25, but the oldest is 35. And if I say that we're going to divide a 1/3 when each kid gets to be 25, a 1/3 when they're 30, and the rest when they're 35, well, the 35-year-old's already met his criteria. He gets everything when it's divided up. The 25-year-old still has to wait 25, 30, 35. So that's not an unusual pattern for us to make distributions out of. The kids are probably going to know it's in a trust. Any one of the beneficiaries can have an accounting of the trust, so they know what it is. The question said, I don't want them to know what it is. And I'm not sure why or what the intent was there. At any rate, question on a durable power of attorney. Mom and Dad have executed their durable power of attorney. That's great. The question read, do I now have to have another power of attorney to help Mom and Dad while they are alive? And the answer is no. The durable power of attorney is durable because it survives the incompetency, or it endures the incompetency of the principal, Mom or Dad. And when Mom or Dad are declared incompetent, then the agent, the guy who's going to take care of things, can act when certain criteria are met. You know, the one doctor signs the paper and all the kids sign the paper, or 2 doctors sign the paper, whatever you want. So execute the durable power of attorney now. Make sure that the power of attorney has the incompetency provisions in it. It needs a durability provision which says it endures the incompetency. And by the way, in Canada, this is actually called an enduring power of attorney. But it endures the incompetency of the individual. Then we also need provisions in it which describe how Mom or Dad are going to be declared incompetent. The 2 doctors, 1 doctor, all the kids, whatever that is, that needs to be written down. I have the power of attorney in place now. Mom and Dad are getting older and they need help. They need somebody to start to act, to do what the power of attorney says the agent should be doing. So we can easily do an early activation. Mom and Dad will sign a paper, it's usually 1 page. Email me, I'll give you an example one. And it says, you know, the durable power of attorney was put in place on such and such a date, and Mom and Dad now want it to be activated even though they are not incompetent. And so we can activate the power of attorney. We do not need to have a second power of attorney and just use the power of attorney, the durable attorney, when Mom and Dad are incompetent. So it acts either way. We can trigger the capacity of the agent at any time. I think that that's all the questions we got. A little shorter than usual, but that's okay. I had somebody tell me that I was supposed to be shorter than last time. It looks like somebody has written in.
Just so you know, there's one in the chat section that came in that was asked ahead of time that didn't get into the report, and then you'll have a number that are in the questions.
How do I get this to be bigger, Soraya? I can't quite read it.
Okay. You have, you're going to do the chat, this one, then there's, see this little arrow? That makes it big over there. Also, your questions we're going to make big.
Okay.
So this is the one that came in beforehand, but after I had sent you the report, and these others are the ones asked.
Okay. The last minute question was, which one? Where?
Sorry, I was getting this ready for you. Last minute questions here.
Does the durable power of attorney need to be recorded in Nevada, the resident state, or is it good in Arizona too? The power of attorney should be good in any state. It does not normally need to be recorded. However, if the agent is transferring real property in order to maintain good title, we're going to have to record the agent's authority. They will record at least a portion of the durable power of attorney to show that this guy had the power to sign the deed to transfer the property. That's why Dad's name's not on the bottom of the deed. Dad's supposed to sign that, not some agent. Where'd this agent get the power? So they will record the power of attorney with the title to show that it's good power to move the piece of property. But normally the powers of attorney are not recorded. And the agent has the ability to act in any state. So that's that question. Let's see on the
Yes.
on the chat. Where's the chat? I lost chat.
That was the only one that was in chat, so we don't need any more on that one.
Oh, that was in chat.
Yeah, that was in chat. And now you've got the questions. You've got a whole series of them. You can scroll down right here.
These are all new?
Yes. They were all typed in during this time.
You guys got way too many questions.
It's all good.
Looking at the single employer HRA simple plan, section 402 says law does not require discrete. That's really, Craig, that's really detailed. Why don't you just call and talk to me? When we get through, give the office a call and I'll answer these for you. Is the single member HRA in Florida, the attorney had us do the Lady Bird deed. What are your thoughts? I'm going to assume that a Lady Bird deed, maybe I could go up and see the person who asked that. You should be unmuted now. The Lady Bird deed, I am assuming, is what I would call a dresser drawer deed. You fill out the deed and it says that when the kids get the property, and then you don't give it to the kids, you put it in the dresser drawer, and then when you die, the kids go and get the deed and file it. Is that what a Lady Bird deed is, Sharon?
Correct. It just automatically transfers it to the kids. No probate, no nothing.
Well, I'm going to say that that's malpractice on the part of your attorney.
Really? Okay.
It's one of the stupider things you can do. There are 2 or 3 points to it. One, you are transferring the property through a deed. When you transfer property through a deed to your kids or your heirs, that is a gift. The kids have to take the original basis. I'm going to unmute you, okay? The kids have to take the original basis. If it's a gift, if they get it because you die, I don't care if it comes through the trust or the will or there's probate, it doesn't matter. They get it because of death. The property will be taxed in your estate. Now in Florida, you can die and pass $5.45 million without having to pay any estate tax. But technically, the property is taxed. The government gives you a credit to cover the tax. But the property is taxed at its value on the day that you die. So I get the property the day after you die and I sell it. My basis was the property, was the value of the property when it was last taxed. The property value on the day you died. So I sell it next week. What's my profit? Zero. I don't pay any income tax. If I get a Lady Bird deed or I get the property because of a deed, then I have to take your original basis, Sharon. That means you bought the house 30 years ago for $20,000 and it's now worth $200,000. So if I get the house through the deed, I sell it the week after you die, I have, what, $180,000 in profit. I'm going to pay capital gains on $180,000. Ah! So I don't think you want to give the property to your kids. You want them to inherit the property. I'll pay the probate versus the tax on $180,000. The other thing is you put it in the dresser drawer. You did not give it to the children. After you died, they came and got the deed. Well, there are certain elements to a deed. It's got to be dated. It's got to have the property description. It's got to have the signature of the grantor. It's got to have the signature of the other guy. It's got to have this. It's got to have that. And it has to be delivered. The law says the kids went and got the deed. You never delivered it to them. Anybody challenges the deed, it is not a valid deed. I'll unmute you. Did that help, Sharon?
Yes, the Lady Bird deed, and I might have to send it to you, doesn't give it to our son until we die. It's automatically ours. We can sell it. We can do anything we want to until we die, and then it automatically...
That is correct. That is correct, but you have not delivered it to your son.
No.
And it is a deed. It is not an inheritance.
Right.
It takes the original basis.
Okay.
All right. Let's see. I've read some things on the internet that suggest that if the HRA funds are, that's going to be all answered after. Grantors do not want two beneficiaries to know what the other two are receiving. Should they use two trusts? They have three. They are able to keep equal value in two trusts as, I'm still not quite sure what that question is, but what we've got is a situation where we want different things to go and we don't want other people to know what's inherited. If it all goes through the same trust, everybody has the right to see what's going on. You could set up separate trusts and you could fund those trusts with certain properties, and the trusts upon your death could certainly direct that one individual would be the beneficiary and receive the entire trust. The other people, they would never have to know that the trust existed. They would never have to know what was in the trust or what happened to it when you died. So yeah, if you had separate trusts for one of these distributions, each inheritance, then the others would never know what happened. I think that's about the best I can do. Let me see. I'll run down the list and see if I can find the individual. I'm going to unmute you. Bernard, did that help? Bernard? Earth to Bernard. All right. Well, we'll assume we answered the question for you. Other questions? Does the single HRA, my gosh, 65 and 45 ages are annual distributions, and 62 and 57 ages are lump sum. That's the same question. Bernard, you're going to just have to call me. That's way too unique. I'm going to have to ask you 10 questions to answer your one. Other questions? I think that's the end of the questions. Craig, go ahead and give me a call. Bernard, go ahead and give me a call, and let's see if we can get yours down, nail down what you want specifically. And that's about right. We've been about 45 minutes. I think we'll try and do this again. I've got it calendared for July 14th. That would be a Thursday. Is noon okay? If any of you don't like noon, speak now or forever hold your peace. Just type in and Soraya can see that. So, all right. By the way, the office phone number is 801-802-9020. 801-802-9020. I appreciate you folks. Those of you who are members, which many of you are, I really am here to help. I'll do anything I can with you. If you're not a member, then check with Soraya, give the office a call, and she can help you with that. I think that covered the questions. So you guys all have a great day, great week, great month. We'll be back and give you an update on what we're doing then. Thank you.